Hello everybody, welcome to iExamB's Legal Bee. This is Amrita, your law faculty at iExamB. In this video today we are going to discuss the important case laws from Indian Penal Code. We have started this series and this is going to be very beneficial for all those who are preparing for competitive examinations, all the state judiciary examinations like UGC NET, etc. Even for CLAT. सो जो भी लोग इन एग्ज़ाम्स के लिए प्रिपेयर कर रहे हैं, जो लॉ डिसिप्लिन से है, उन्हें कुछ लैंडमार्क केसेस पता होने बहुत ज़रूरी है. सो आई वुड सजेस्ट दैट यू गो थ्रू दिस वीडियो एंड ऑल्सो चेक द डिस्क्रिप्शन ऑफ दिस वीडियो फॉर more cases and the summaries that are provided. Due to the length of this particular video, I cannot take everything in one video. So I have provided the PDF in the description. So do check it out. Other than this, we have also started another series for the recent judgments. इन वीडियोस में मैं लैंडमार्क जजमेंट्स के बारे में बात करने वाली हूँ. इसके अलावा रीसेंट जजमेंट्स की भी एक सीरीज़ है. आई वुड सजेस्ट कि आप लोग चैनल को जल्दी से सब्सक्राइब कर लीजिए एंड प्लेलिस्ट में जाकर सारे वीडियोस को चेकआउट कीजिए. ये सीरीज स्टार्ट हुआ है जनवरी 2023 से. एवरी 15 days you get the recent judgments from Honorable Supreme Court and the important judgments from High Courts as well that are compiled together in one video, and you also get the PPT downloaded from the description of that video. So every 15 days if you're getting the recent updates, recent judgments and also the landmark judgments at one place, that is Legal Bee only. So don't forget to subscribe to our YouTube channel and stay updated. Indian Penal Code also has various important judgments, and I would suggest that you should go through all these judgments, that IPC, Constitution, all these are the subjects from which judgments are the best thing that an examiner can ask you in exam, especially judiciary exams में तो बहुत पूछा जाता है. So please आप ये सारे judgments को thoroughly पढ़ लीजिए, at least the summaries. You should have an idea that what was the ratio in that particular case and also the year in which particular case was asked. UGC NET एग्जामिनेशन के लिए तो आपको मैच द फॉलोइंग में काफ़ी ऐसे क्वेश्चंस पूछे जाते हैं जिसमें आपको ईयर पता होना बहुत ज़रूरी है. Starting with the first one, Tukaram versus State of Maharashtra, custodial rape case, also known as Mathura rape case. In this case, it was held that the onus was on the prosecution to prove that all the ingredients of Section 375 of IPC were present. And if there is a sexual intercourse which is consented, which was held in this particular case, that the victim had voluntarily entered into a sexual intercourse. But after that, we have had a criminal law amendment in Indian Evidence Act as well as an IPC. In Indian Evidence Act, now we have a presumption in favor of the victims of rape that they are not consenting to such kind of acts which are sexual intercourse. And in IPC, custodial rape has been recognized after this particular case. So this is a very landmark case. Lakshmi versus Union of India, very important landmark case in acid attacks. It provides guidelines for the advancement and development of laws that are relating to acid attack offences. It has provided for amendment in the laws for acid attack, and IPC has been amended. Section 326A and 326B has been added to IPC, that is punishment for throwing acid. And CRPC also has been amended to provide Section 357A and C, which are providing compensation to the victims who are survivors of acid attack. And if they go to hospitals also, they should get pre-treatment, whether it is a public hospital or a private hospital. State of Maharashtra versus M.H. George. This is also another interesting case as it is relating to the jurisdiction of IPC. We can say that if an offense has been committed in India by a foreigner, he cannot take the defense that he was not aware of the laws. We all know ignorantia juris non excusat. That means what? You cannot say, you cannot take a defense that you were not aware of the legal provisions of the particular territory where you are. So he was held as liable for the offense and he could not take that particular defense. KM नानावटी वर्सेस स्टेट ऑफ महाराष्ट्र, ये भी एक बहुत ही कॉमनली डिस्कस्ड केस है बिकॉज इस पर एक मूवी भी बन चुकी है जो कि आप सब ने देखी है, रुस्तम. So everybody knows the facts of that movie. So this case is actually KM Nanavati versus State of Maharashtra, relating to accused conviction under section 302 of IPC. Grave and sudden provocation is the defense that has been taken in this particular case by the accused, and on that basis the jury has actually given a verdict. At that time there was jury system, so jury has actually acquitted him, but legally the case then went to the Supreme Court, and the Supreme Court has held that the accused conviction under section 302 of IPC, and he was sent to jail for life. Sentence of life imprisonment was imposed by him, as it was imposed by the High Court, that was held as legitimate by the Honorable Supreme Court. And the ratio that is held is that grave and sudden provocation is not established. The reason being that the cause which we say of grave and sudden provocation is the wife's confession of a relationship with some person who is actually the deceased. After that, there was a time gap of 3 hours. So that 3 hours time gap is enough for a person to cool down and realize that what is the actual scenario or the situation. So we cannot say that after a time gap of 3 hours he was under a grave and sudden provocation, that in that sudden moment he has committed the murder. So this defense could not be established in the proper manner, and thus conviction was held under section 302 of IPC. Navtej Singh Johar and others versus Union of India, very very important judgment. It has held that homosexuality is not a crime anymore. This has given relief to many various same-sex couples in India. It's a very landmark judgment, and इससे काफ़ी बार questions पूछे जाते हैं. I would again suggest कि आप year भी याद रखें इन सारे cases का. मैंने यहाँ पर include नहीं किया है, but you can go through all the years as well. It was held that section 377 of IPC is unconstitutional to the extent of consensual sexual acts between adults. There is some part of section 377 that talks about intercourse with animals, for example. Those parts are still an offense, okay? That is still amounting to an offense as per Indian Penal Code. Only consensual adult sexual acts between same sex is not criminal act anymore. It has been decriminalized now. Joseph Shine versus Union of India. It is very very important judgment again, as it is held that section 497 of IPC is violative of articles 14, 15 and 21 of the Constitution. You should remember that which articles of the Constitution are held as violative over here, and the section number also is very important. It has been declared as unconstitutional. The provision is discriminatory, as it is, of course, IPC was drafted at the time of 1860. So if the provision is violative of articles of the Constitution, it has to be held as unconstitutional. And the important point that we have to note over here is that the court has held, even if there are negative effects of the failure of parties to a marriage to be faithful to each other, if they are indulging in adulterous acts, then also it has been left to the parties to decide how to proceed further. If they want, they can take divorce with each other. Criminal sanctions are not needed as of now in these acts. That was held by the court in this particular judgment. So this is another very important judgment, landmark judgment in Indian Penal Code, and I would suggest that you should go through these judgments. कई बार students को confusion हो जाता है, जो कुछ judgments होते हैं जो recent होते हैं, like Joseph Shine judgment and the previous judgment that we just witnessed relating to same-sex couples, Navtej Singh Johar. Students confused हो जाते हैं कि 377 नवतेज सिंह जोहर में था या 377 जोसेफ शाइन के जजमेंट में था, and they ask you the questions in this way that they try to confuse you and you get confused. So be very clear with these landmark cases, with the provision that was involved, what was the ratio that was held in this particular case. That should be very clear. And for more clarity on the point, I would suggest you should download the PDF that is there in the description of this particular video. There are more case laws like Nirbhaya rape case, Mukesh and another versus State of the NCT of Delhi. That case is also very important as it has led to the Criminal Law Amendment Act 2013. Criminal law amendments also very important for you people. Bachchan Singh versus State of Punjab, very important, relating to rarest of rare doctrine. ये सारे cases को देखने के लिए download the PDF and check the summaries of all the important landmark judgments from Indian Penal Code. And also I have some update for you, that is iExam is organizing a free workshop with Robin Dutt sir, who is a senior counsel designated at Punjab and Haryana High Court. He is also practicing at Honorable Supreme Court of India, and he is going to guide all the people who are belonging to law faculty, law students, law discipline people, lawyers, queries relating to litigation, judiciary, assistant district attorney. All these guidance you are going to get, so go soon and register it. Check out the details at www.iexambi.com. There is also a course that has been started, Judiciary Revision and Practice Test course. It is an online course for 6 months. You will be getting 2 tests each for mains as well as prelims in a week. You can solve it, and also one class will be there, weekly class will be there for mains answer discussion as well. So this is a very good opportunity for you. Download the test plan as well and check out all the details. Don't forget to subscribe to iExambi, Legal Bee. Prepare 50% faster with us. Thank you.